Hi, I'm Jason Sullivan of Rathbone Group, and in this video of On Subrogation, we're going to talk about arbitration forums and some of the jurisdictional issues that may arise in that venue. If you're handling subrogation claims, you're probably familiar with arbitration forums. It's a private company that's created a platform and venue for insurance companies and self-insured companies to bring their claims against other companies that have agreed to be members. That's the real first key is, for arbitration forums to have jurisdiction over a claim, all parties must be signatories. If you are company A and you're filing against 3 parties, 2 of them are members of intercompany arbitration, and the third is not. You can do that, but the issue will be that you can only file against the 2 companies that are members of intercompany arbitration. Those parties can then point to an empty chair, the party that's not a member and isn't subject to the authority or control of arbitration forums. If the panel finds that those 2 parties aren't liable and that third party is liable, there is no award against that third party. You have no rights to collect because there's no award against the 2 parties that are members, and there's no award against that party who hasn't consented to the jurisdiction of arbitration forums. In those cases, you really have to think hard. Are you willing to be bound by an arbitration award that, pursuant to the rules, forecloses your ability to go after that non-party after the award is entered? Or are you going to use an alternative such as the state court venue to pursue all parties to avoid an inconsistent or potential response that doesn't allow you to collect your full damages? There are additional affirmative defenses that may be raised that also will take a claim outside of the scope of arbitration forums. The first would be no coverage. You, as Company A, are filing against Company B, claiming that Company B insures John Doe, who is responsible for damages. Company B says, well, wait a minute, we don't even have a policy of insurance for John Doe, so why is this being heard in arbitration forums? If Company B does raise that and they provide a letter that they sent to John Doe stating that there's no coverage for this particular loss, then that takes the matter outside of the jurisdiction of arbitration forums. If no such letter was sent, Company B can still raise the defense that they don't have coverage, but the panel will then hear the case on the merits and decide whether or not there's evidence of coverage or no coverage, and then make a decision which would be binding on the parties. The other area is a monetary threshold. For most of arbitration forums, there is a $100,000 threshold. They have authority over claims under $100,000, but not over $100,000. The exception currently is for special arbitration. In that case, there's an authority level up to $250,000, but not above. Another area is policy limits. So if there is a policy limits defense being raised, arbitration forums does not have the authority to issue an award beyond those policy limits. So to take the example, you're the filing company and have a $43,000 property damage loss. You file in arbitration forums against Company B, who's a signatory, but they raise the affirmative defense of only having $25,000 in policy limits. If they properly raise that defense, arbitration forums cannot exceed that amount in what they award to Company A. Company A has a choice. They can either file, be aware of the arbitration limits up to the policy limits once that affirmative defense is raised and agree to accept it, or they can withdraw and say, we're not willing to accept those policy limits. We want to reserve all of our rights to pursue the full balance of our damages. But they're going to have to do that in a different venue other than arbitration forums. Once you do win an arbitration award, how does it get paid? Well, under the rules, you have 30 days to pay an award against your company. If that company fails to pay, the filing company and the company that won then sends a letter demanding payment. If another 30 days pass by and still no payment is made, that filing party, the winning party, can then seek the assistance of arbitration forums. Arbitration forums will notify the non-paying party that they have the obligation and responsibility to pay. If now another 30 days passes, so we're looking at least 90 days after the award is entered, and there is still no payment, the winning party has the right to seek legal recourse. Under Rule 5.2, that party has the right to seek not only statutory interest, but the fees and costs in enforcing that award. That enforcement takes place through the state court system. Most states have adopted the Uniform Arbitration Enforcement Act, in which you go through a process to have an award confirmed. That is a state court process, though, and is not done through arbitration forums. The final issue that comes up frequently is, what about the statute of limitations, and how does an arbitration filing affect that claim? There are two scenarios. The first would be you file an arbitration, the statute of limitation then expires, the responding party raises some affirmative defense or other issue that takes it outside of the jurisdiction of arbitration forums, and so now you want to pursue through state court. But that statute of limitations expired before that affirmative defense was raised. So what do you do? In that case, unfortunately, the filing of the arbitration and then the subsequent expiration of the statute of limitations is going to be binding, and you're not protected, and that statute has expired. There's probably not any way that you can argue that the statute should somehow be extended. The other scenario would be you file a lawsuit. The statute of limitations expires, and then the other party claims that this should be heard in arbitration forums, and they're correct about that. Now, under the rules, you have 60 days from that demand to move it to arbitration forums to dismiss your lawsuit. If you refile or file for the first time in arbitration forums after that dismissal, now you're protected, because filing the lawsuit does toll the statute of limitations, and pursuant to the arbitration rules, you have 60 days after the dismissal of your suit to file in arbitration forums. So anytime that you're faced with a closing statute of limitations and you're thinking, should I pursue with litigation or should I pursue through arbitration forums? If you pursue through arbitration forums and then something happens that takes the case out of arbitration forums jurisdiction, you risk not being able to proceed on that claim if the statute of limitations expires before you're able to file your civil lawsuit. It's the opposite if you were to file your lawsuit first and then discover that arbitration forums does apply, even though the statute of limitations has expired. You have that 60-day window to dismiss your lawsuit and file in arbitration forums. For On Subrogation and the Rathbone Group, I'm Jason Sullivan. If you have any video topics or questions you'd like to have us address in these videos, please email us at video@rathbonegroup.com. For Rathbone Group, that's the long and short of it.